welcome you, and you can
Thank you.
start with your opening statement whenever you're ready.
Thank you. Well, as I said, good morning. My name is Jennifer Slocum Bailey. I'm a District Associate Court Judge from Judicial District 8B in Des Moines County, Iowa. I preside where I am from. It's my hometown, as well as the only county in which I preside. I'm also the only applicant from the 8th District, and I'm proud to represent them in this process. A little bit about myself. No one in my family is an attorney. I found an interest in the law independently. I knew I wanted to be a lawyer from a young age. My mother was a nurse, and she worked on her master's degree when I was in elementary and middle school. And she pursued that degree in clinical psychology. During that time, we were a team. I learned to type, and I would type her papers as she dictated them to me. She also, in pursuing her master's degree, had some difficulty insofar as she's deaf. She relies on cochlear implants at this point in her life, but she encountered a lot of hardship with professors who didn't want to provide reasonable accommodations, using a microphone, recording lectures, things like that. And so I learned from an early age the hardship that comes from injustice, and a lot of my passion and value in education has come from those experiences, as well as my pursuit of justice. I went to the University of Northern Iowa. I went there on scholarship and was a scholar at the College of Social and Behavioral Sciences, and I chose to be a criminology major because criminal law is unbelievably fascinating to me, at least, but also because I knew I wanted to go to law school. And so I attended there. As an aside, I've taken coursework in criminology, but I've also taught criminology courses for 7 years at Iowa Wesleyan University, including all manner of theory of punishment, sociological theories of crime, gang activity, substance abuse, penal institutions, those kind of things. And I will say, although some people say their undergraduate degrees haven't impacted them very much in their actual day-to-day jobs, it certainly did for me, and teaching as well. I graduated with a 3.97 grade point average, getting that A- the last semester of my senior year. I was the purple and old gold recipient for the highest grade point average in my major. I'm also proud that throughout my college career, I had leadership roles. I served on the executive council of my sorority for 4 years, ultimately becoming its president. My senior thesis, which I presented at a symposium in Atlanta, Georgia, analyzed the addition of female Supreme Court justices on legal outcomes. I attended the University of Iowa. My goal was to graduate with distinction in the top 20% of my class, which I did. I was able to do so. I also competed in the Baskerville moot court competition and was an editor on a law journal. And my interests there expanded well beyond criminal law, and it was an exciting time to see beyond just the scope of the narrow view of the criminal law that I had passionately pursued before. I was slated to begin working at a law firm in Waterloo, Iowa, and was excited about working there doing civil litigation, employment law, union law, a lot of different kinds of litigation. I graduated from the University of Iowa in May of 2005. My older brother and only sibling suddenly passed away just a few weeks later. My plans were dashed in a lot of ways, and my priorities shifted. I moved back to my hometown, something that if someone had told me I would do, I probably would have balked at. But as I look back, it's been an extraordinary blessing insofar as my career and my personal life. I helped raise my brother's daughter, who was 3 months old at the time of his death, and I law clerked at Aspelmeyer Law Firm as I was delayed in taking the bar from his untimely passing. There at Aspelmeyer Law Firm, I was mentored by a lot of really great litigators, and I got my foot in the door of private practice, so to speak, and I practiced for about a year. And in doing so, I did a lot of guardian ad litem work in juvenile court cases, mental health committals, dissolutions, child custody matters, insurance defense, and helped represent the city of Burlington in civil litigation. In law school, I had clerked at Lane & Waterman my first year. I clerked at the Lynn County Attorney's Office. I also clerked at the Johnson County Attorney's Office. And I had had a passion ignited for criminal prosecution and, of course, obviously have an interest in criminal law. And so when the Des Moines County Attorney's Office had an opening after a year in private practice, I pursued that, and I started that position. In the 7 years I worked at the Des Moines County Attorney's Office, I handled a lot of criminal matters. I gained significant jury trial experience, attended national trainings. I self-appointed myself as the specialist of victimless prosecutions in domestic violence cases where women were either absent or uncooperative. I garnered a positive jury trial record of 17 favorable verdicts, 2 unfavorable, and 1 hung jury. And I prided myself in taking difficult cases to trial, and I found success and favorable outcomes to the state of Iowa. During my time at the Des Moines County Attorney's Office, I also got married and married my husband Jake, and we started our family. My daughter Brielle is 10. My son Jameson would be 9. My son Bronson will be 8 next month. In September 2012, our son Jameson unexpectedly passed away at 3 months old. I share this because it has undoubtedly given me a different perspective in many things I do personally and professionally. As a prosecutor, when I spoke to people who lost children, who lost loved ones, it came from a place of knowing. Not so differently, when I terminate parental rights, I know what it is to not be able to raise your child, and that perspective is never lost on me. There is a maturity born from that kind of pain, and I take that with me in all of my roles. After 7 years at the Des Moines County Attorney's Office, I was ready for a new challenge, and I went to the Public Defender's Office. That was a leap of faith. I was a zealous advocate for the state, and I was ready to be challenged and try something different, and I wondered how I would fit in that role. It was overwhelmingly positive. Being able to handle especially indigent criminal defendants and understand and speak to them directly in a way that you cannot as a prosecutor, cannot as a judge, is incredibly valuable. And I take that perspective in every criminal case that I go into, and I'm able to tell the litigants in jury trials, I've sat where he sat, I've sat where she sat, I sat here now. I understand the unique perspectives of everyone in this courtroom, the unique job and the hardship that they each have to carry in order to do that job. I believe that that balanced experience makes me a unique candidate insofar as both my experience in litigation, particularly criminal litigation, but on both sides of the table. So what you're likely thinking is, what would I contribute to the Court of Appeals? And so after 2 years at the Public Defender's Office, there was an opening on the District Associate Court bench, and I applied and was appointed to that position. My husband and I also had our daughter Bellamy, who just turned 3, our last child. Some hard facts about me as a judge. I have never had to report via a 2210 report that I've taken longer than 60 days to rule on any matter. In the retention election in 2018, I had the highest rate of retention in Des Moines County, again, the only county in which I preside, and that was at over 83%. My plebiscite results were overwhelmingly favorable, of which, for anyone unfamiliar, is a survey given to attorneys that appear in front of you and give their honest feedback about all manner of things. And finally, to date, I have not been reversed by the District Court, the Court of Appeals, or the Supreme Court, despite regular appeals to the District Court, the Court of Appeals, in small claims, criminal, and juvenile caseloads. So a few things I want to point out before questions. Again, my criminal experience being a prosecutor, a public defender, and as a judge, my juvenile experience being a prosecutor, a public defender, a guardian litem, and as a judge in those matters. I have shown a dedication. I have been a public servant to the state of Iowa for 15 years, almost the entirety of my career. I have also a lot of time left to make a mark on the Court of Appeals and also perfect the art of being an appellate court judge insofar as appellate writing and decision making. I've been asked a lot about whether or not it's necessary to be a district court judge prior to sitting on the Court of Appeals. And so I take a strong position on that. My role and my job sitting on the bench at the District Associate Court is a strength. It is not a weakness. Under our Constitution, restrictions on our freedom and our ability to raise our children are protected. If someone asks me what I prize, it is my freedom, it is my children. And we saw a shift in prioritizing juvenile cases when Chief Justice Turnus took to the Iowa Supreme Court. It continues today under Chief Justice Christensen, who spent the majority of her time before being on the Iowa Supreme Court as a District Associate Court judge. Overall, it's been said that roughly 80% of the cases heard by the Court of Appeals are family or criminal law. And looking at the opinions, the last one released, I believe, June 16th, in my own rough calculation, about 60% involved criminal or termination of parental rights. So I guess I would ask if someone has never done juvenile work, never done criminal work, has never sat as a district associate court judge, and has had to navigate the difficult policies by the Department of Human Services, the ever-changing services available, has never had to look a parent in the eye, a child in the eye, tell them they're not going home or that they are, if they have never had those experiences, whether or not that's necessary to be on the Court of Appeals given the heavy amount of juvenile work that is heard. Moreover, as it pertains to my contribution to the Iowa Court of Appeals, I take a lot of pride in my legal writing, and I understand the great volume of opinions that the Court of Appeals puts forth each year. I enjoy writing, and I realize that it is a vastly different job than what I'm doing right now, which is primarily on the bench, and having to really ration out my time in writing any length of a decision. But I'd like to read an excerpt from one of my child need assistance cases that was appealed and affirmed after I terminated the parental rights of both parents. It's in the interest of DW and TW, 953 Northwest 2nd, 183, an Iowa Court of Appeals decision from 2020. There are certain things that can be quantified and certain things that cannot. This court cannot quantify the bond enjoyed between TW and DW and their parents. This judge has been privy to hearing DW squeal with delight as he was able to speak to his father on the phone from prison. When the father was around, which wasn't much of TW's life, but a few years of DW's, he did something to cause a real bond to form between he and his boys. They sincerely loved their dad. When they were in their mother's care, they talked to him on the phone from prison every day. The same can be said for the bond these boys have with their mother. It cannot be quantified. They love her desperately, and she is a good mom for short periods of time when she is sober and not in a mental health crisis. However, there are things that this court can quantify. 44 months is the number of months the Department of Human Services has given the parents services. 24 months is the length of time these boys have been removed from their parents. 9 is the number of foster homes and relative placements these boys have endured. 6 months is the amount of months in this case the father was not in jail or prison. 5 is the number of times the parents have successfully completed inpatient substance abuse treatment in this case. And 0 is the number of months longer that these boys should have to wait to see who is going to raise them. More importantly, I adopted these boys out last month, and that was a beautiful moment. The word integrity is peppered throughout the Code of Judicial Conduct. We as judges are tasked with not only knowing the law, but also having good character, being trustworthy when no one else is watching, and inspiring those that appear before us to do the same. Independence, integrity, and impartiality that is seen all over the Judicial Code of Ethics. That is what I've learned from 16 years as a private practitioner, a prosecutor, a public defender, and a judge. It is a culmination of a life lived and my overwhelming desire to do justice. Now my focus has shifted to the Court of Appeals. With its voluminous docket and complex legal issues, I am ready to be challenged anew. As I hope I have illustrated, when I choose to do something, I do it well, and this will be no exception. I'd be happy to answer your questions.
Thank you. Commissioner Sukup, would you like to start?
All right, thank you. Very impressive with all the diverse background between private practice, prosecutor, and defender's office. Which case would be sort of the most impactful, would you say, for yourself?
I think that would really depend on different parts of my career. So I cited one case from 2007 that was a traffic ticket case, and that involved the death of a 19-year-old boy. The defendant was charged with 2 traffic citations, but again, it involved the death of another individual. It involved some of the most honestly complex legal argument that I had to make to a court insofar as the code sections applicable involved a vehicle, and there really was a hole in the law as to whether or not, because he was riding a bicycle, whether or not the right-of-way as distinguished in the code sections would apply. I argued under civil law. There was some precedent involving civil litigation, and the judge denied the motion to dismiss, went to trial. It was a 2-day trial. Convicted, the defendant was, and then it was appealed to the district court, and I was affirmed. That was impactful because it was challenging, and I also, the mother was there every day. Incidentally, she lobbied after that, and the law was changed. I think it's 32199 was added, which applies to bicycles. It showed a really beautiful, I think, synopsis of our justice system working correctly, but also our legislative system working correctly. As far as being a prosecutor, having murder in the second-degree trial, that was impactful. I was in charge of getting in all the forensic evidence, so that kind of direct examination and surviving cross-examination was complicated and fulfilling. It also involved an arson, so obviously there's a lot of physical evidence involved there. So that was really interesting. I could go on, I guess, being a public defender and representing different people in serious cases and trying to help them was also impactful. But I guess I could go on and on for every role that I played, but off the top of my head, those have been really important to me.
Thank you.
Mm-hmm.
Commissioner O'Brien? Thank you.
Good morning, Judge. Iowa's criminal justice system has a huge disparate impact on people of color. And the last numbers that I saw were 71% of the people incarcerated are people of color, and only 7% of the population. Do you see any issues in your role as an associate district court where the system should be doing better to address this disparity?
Well, there's a lot that can be said on that issue. I think if you look across not only criminal matters, but you look in child native assistance cases for rates of removal and foster care placement and not relative placement, if you also look in juvenile delinquencies and the rate of African American children and other minorities placed in detention, you would see a lot of disparity as well. So that is never lost on me. I think there's a lot to be said on the matter. I don't really know where to begin, to be honest. In child native assistance cases, I have felt a lot that I remind workers and attorneys that they need to put away their middle-class measuring rod, so to speak, judging behavior and coming from a place of misunderstanding of certain actions, of more awareness culturally and also within the families. I've also, through parent partners and other corollary agencies, when I know a family who is of minority status and they're in a room with individuals who do not look like them, that I've brought in other individuals so that there can be a feeling of security and also a better dialogue between parents and with the court. As far as criminal work, there's a lot of work to be done in that regard. I think that being aware is the most important thing, and checking yourself in regards to that. And I think also looking at each offender individually and looking at each crime individually, I think that a lot of times there becomes a natural crescendo as a prosecutor, and I believe I was somewhat guilty of it insofar as looking at their criminal record, any defendant's criminal record, so to speak, and building upon the length of time that they serve in jail, and that each prospective offense would then increase instead of looking at the individual's circumstances at that time and what best suits them, whether that be supervision, and there not being a foregone conclusion that incarceration is what we're building toward, but looking at it individually. I recently had a case and it involved an African-American defendant, but he absconded and there was a probation violation complaint filed. The state argued for revocation of his sentence in its entirety. When we got to dispositional hearing, as he had admitted that he'd absconded and violated his probation, I mean, really the crux of it was that there was a hole in our substance abuse programming and there wasn't any vacancies for him to go to inpatient treatment as his evaluation is recommended. He absconded to go back to his hometown and he completed inpatient treatment. He had a job as a supervisor. He was back with his family. He was providing for his children. And so when the state argues for, kind of blindly, because as a matter of course, looking at his history and then also looking at the fact that he'd absconded from supervision for, about a year, what I did in that case was to admonish, a bad decision insofar as not communicating and that sort of thing. But he had sat in jail for 60 days awaiting disposition and being extradited from Illinois. And I gave him a contempt sentence. and I continued his supervision so that then he could go back, complete his aftercare treatment, continue in his role in his job, and that sort of thing. So I think you have to look at each offender and their circumstances on that day and what's best for them and the community. And I think that if you look at it in that way, it will address a lot of the disparity that we see.
Thank you.
Thank you, Judge Bailey. Our time is up for today. We thank you for your application and we wish you the best.
Thank you all.
Thank you.
Thank you.